Good morning, everybody, and welcome to the work session on SB 134. And before we begin, everybody could join with me to do the Pledge of Allegiance. Okay, so thank you everyone for coming out today. So this is a follow-up to the work session that we had 3 weeks ago. So 3 weeks ago, basically what happened is we went through, we reviewed the requirements of the federal One Big Beautiful Bill legislation, and we did a side-by-side comparison of how that looked relative to the language that we had passed back in 2018 and tried to implement in 2019. And so a lot of the discussion talked about some amending language that was provided to the committee that had been drafted in conjunction with the department, the prime sponsor, and had, I guess, the approval of the governor's office. Which basically kind of pivoted away from the original direction of SB 134, which was looking at a waiver going towards a plan that would be closely tied to the federal legislation. What that would do, that basically would put us to the front of the line, and it would also basically allow that as the federal government made any changes, since our state legislation was closely aligned to the federal legislation, we would be able to pivot, and that would minimize the risk that we would be dropping folks along the way, and that's obviously a very important consideration in everybody's mind. So we had not, though, had an opportunity to really go through that amending language in any detail. So, in terms of depth of review, so the members of the committee asked if we could go take a little bit of a breather, take a few weeks, look at the language, understand it, see if there were any red flags. And so the committee members have had an opportunity to do that. And so what I wanted to do is get everybody together to kind of talk through that. I think, our goal today is going to be to kind of understand, what are the differences with the amending language that we have before us. Hopefully we can come to some kind of agreement on something that we think is going to work so that we can get a formal amendment drafted, because I know that Chairman McDonald is looking to get the full committee back together either on the 5th of November or the 12th, depending upon the scope of the changes that we're looking to make. Okay, so that's kind of where we're at, and with that, I would throw it open to the members of the committee first. To just see, having had this time to review, if there are any thoughts or concerns that anybody might have. Representative Goldfault.
Thank you, Mr. Chairman. And I guess first I would like to thank Director Lippman, and I think the information and the overview that we got at the last meeting was extraordinarily helpful. I understand that some of the side-by-side, which I'm kind of looking for my copy of the side-by-side online here, but the side-by-side I thought was especially helpful. So I understand that there are a number of areas where states have latitude to determine, how they're going to handle eligibility and verification. And so I have a number of things which I have included in a handout, and I apologize, this is not necessarily real polished in terms of what I'm giving you. It is definitely not OLS language at this point, but this is kind of going through some of those areas where states have latitude to make a determination how they're going to handle look-back periods and verification of eligibility, things like that, and is tightening those up. So what I would like to do is perhaps go through those one by one, invite Director Lippman to provide comment on sort of what are the implications of those proposed changes for the state and the program, with an eye to deciding as a subcommittee of, which of those do we think we might want to include in an amendment if we should want to bring an amendment forward. Before we go there, let me just say there would be a change. So these would be in addition to the language that has already been proposed. And there is one change that would need to be made to that language. Specifically, that language says provisions in RSA 126AA2 related to community engagement and work requirements shall be suspended. And essentially the idea is that these would be suspended unless or until the work requirement is revoked at a federal level, in which case those provisions would kick in again. That would need to be modified if we add any of these provisions. That would need to be modified to make sure that these provisions would apply. In other words, these would not be included in the provisions to be suspended. So it's sort of a minor but important thing that would change, that would need, I think, to be made to section 2 of the proposed language.
Is it your belief that any of these provisions that that you're bringing forward, fall outside of the federal intent, or is this just kind of clarifying where we have latitude, kind of clarifying that?
It is primarily it's the latter. So my understanding is that all of these would, and I'd like to hear Mr. Lippman's comments on them, but my understanding is that these are all areas where the federal government has provided some latitude, and we could potentially sort of state in statute that we would want DHHS to set standards in a certain place. So, and I think that will make more sense as we go forward. So the look back period, for example, states are allowed under OB3 to go 1 to 3 months.
Correct.
And, so what I'm suggesting is that we put into statute, it's 3 months. So that's where I would like to hear comments from the department on the implications of some of these proposed changes.
Okay, we're okay with that. So Director Lippman, why don't you come up and let's go through these one at a time.
So the first couple of lines, the definitions, essentially is just setting the stage for the remainder of what is here. So the first specifically references that look back period of 1 to 3 months. And there's actually two elements. Yes, so this is the one I just handed out. There were a few copies. It looks like those have been picked up.
I have one other copy up here, so if anybody's looking that doesn't have a copy.
So specifically, this deals with two elements. One is the look back period. The individual must have demonstrated compliance with the work requirements for 3 consecutive months immediately preceding the month in which they apply. And then the second is that self-attestation is not acceptable. And I understand that the department's intent at this point is that self-attestation would only be acceptable as a last resort. But if an employer, for example, is not forthcoming with information, yet we do also have, employees should have access to pay stubs, and I would think that is something that people ought to be able to produce. So I guess I would put that out there, and I guess just for the sake of, if anybody doesn't have this, or people are looking or listening online, I can read this paragraph. No applicable individual shall be enrolled in Medicaid unless at the time of application, the individual demonstrates compliance with work requirements for the 3 consecutive months immediately preceding the month in which the individual applies. The Department of Health and Human Services shall require documentary evidence and shall not accept self-attestation at the time of application.
It's okay if I comment?
Please.
So I think the 1 to 3, as Representative Koval has lifted up, is a policy choice. The part about documentary evidence, I think, in terms of someone proving their work, I guess the question I have here is someone, say, is hospitalized, right, and they had not planned on being on Medicaid, right, that the condition that led them to being hospitalized. In terms of being able to prove that, they would not be able to prove the prior 3 months. The only way I think they could get on would be through an exemption, right? A qualifying exemption. I just want to make sure that a qualifying exemption isn't precluded in terms of that initial situation, because then what we're doing is passing on more uncompensated care to the healthcare system in terms of that, and then also for the individual who may have had a sudden condition that, in terms of being able to get continuing medical care, that might be an issue there. That's I guess the consideration, because I think the 1 to 3 is a policy choice. The issue of someone who's trying to get on for the first time is what we're dealing with in this paragraph, I believe. So I do think that there are medical situations that, or like if they're a parent of someone who's under 13 years of age, they would qualify for an exemption right out of the that providing evidence of that's not such a, but I just think of someone who's in a medical situation that this may represent some delay that I'm not sure we want to have, but that's I think one thing I would just raise with the inability to accept certain situation, or if someone was in an accident and couldn't produce the materials to that may put them at a disadvantage.
So would the person, I think we're saying the same thing. Would someone who has a medical condition under those circumstances and is unable to work and unable to provide evidence of work, would they not, kind of by definition, not be an able-bodied adult? And I think that's what you mean when you said if they would have an exemption,
Right.
They would.
Right. I just want to make sure we're not eliminating someone who isn't able-bodied, but if they can't prove that they're not able-bodied, then would we be in a position of denying them the coverage? In other words, maybe the hospitalization is maybe not the best example, but the concern I have is for people who would have to want to take advantage of an exemption that they're rightly entitled to, who couldn't provide that documentation.
So if we were to do this,
Yep.
Because the discussion that we had 2 weeks ago, and I'm probably going to ask the same question as we go through every one of these, so I'm going to get like a broken record, but the point is, we're trying to attach this as closely as possible. So if we were to, within the language of the amendment, say, guess what, self-attestation is it. Within the federal language, are we covered by that in order to allow those exemptions, or do we have to write in an exemption that maybe starts to move us off the path?
if I
of the federal.
Sure. Sure. If I could maybe offer a suggestion, maybe would be that, shall not accept attestation at the time of application, but make it subject to a rule that's approved by the legislature or something like that, so that as we sort of put this together, that if there's something that makes sense to the legislature, you have a chance to make that policy decision as opposed to, you know, that makes sense to you.
So it doesn't make sense to me. So it's when you say it's subject to some rule approved by the legislature, that's you're either talking about administrative rules,
Yeah.
which are, go through JLCAR, or putting in a statute. So it's either we're either making that change here as a policy decision, or we're authorizing DHHS to make rules with respect to that piece.
Okay, then how about, in terms of, we have to submit the document to get approval for the federal requirement to the fiscal committee, right? That the approval would happen there, right, as to whether there's any flexibility there. So I guess a suggestion, but
You mean to the fiscal committee on an individual basis?
in other words, I think the legislation, the core of the legislation requires us, before we submit something, to get approval, submit it to the fiscal committee, correct on that? Yes. As to whether, if there's anything more that we learn that's useful here in terms of a special circumstance that you would want to consider, that we'd have the opportunity to present that there, and if not, that would drive it, if you will, the way you have it written.
Okay.
Okay,
Mr. Chair?
Representative Woods?
Yeah, this raises a question I've had right along, and that is, as we go through this and we sort of identify potential, potholes, what mechanism and what restraints are in place if we find that down the road, I don't know how far that would be, that that really should be A instead of B. How subtle or how difficult will such a change be, and what would be that mechanism? Because just like this situation, as we find as we go along that this attestation needs to be changed in some way, do we have to go through a full legislative remake or rulemaking, as has been suggested? And I think a lot of what we're doing here will also fall into, we're doing this to the best we can, but as we put it in place, we may find that, we really meant this. If it didn't turn out quite that way, we'd like to make a change. And how that occurs could be a bit of a bottleneck.
Yeah, and I just to follow up, and I'll let you answer the question, is this for me is the biggest concern, because I think to the extent that we are able to get documentary proof and stay away from self-attestation, I support it. It's easier for the person getting the benefit. It's easier for the department. But I can understand how that could be taken advantage of. But on the other hand, I want to make sure that we're not stepping out into a situation that makes us vulnerable. So with that additional comment, I'll let you speak to Representative Wood's question.
And Representative McLean, I will likely defer to Director Lippman on response to that. But overall, I just wanted to come up and make a commentary that I totally understand the approach here is to go paragraph by paragraph to identify what is in alignment with HR 1 OB3 and where are the limitations and barriers that state law could create in reference to trying to align both the federal law, because that's what we came here for, was to have us again get first in line for purposes of getting our approval through the federal government, through CMS, but also your earnest efforts in terms of accountability is certainly, we recognize and acknowledge that, To the extent that there are policy considerations like the 1 to 3 months, as Director Littman has mentioned, but if you go beyond the scope of what is otherwise allowable in federal law, you may run into some barriers. So one suggestion, and this is something to bring up with the drafting attorneys at the Office of Legislative Services, since they have possession of this, is there is standard language that's utilized that means in compliance with federal law. It could be an additional add-on to that one sentence where it ends with application and saying exceptions, exclusions as otherwise recognized by federal law. I think that gets you around that barrier, and I think that was the goal of what this committee is attempting to do and why they're bringing up Director Littman. And with that, I'm going to go back.
And I would concur with what the counselor just laid out. That was actually, I think in general, would apply to anything here because we know that the federal regulations haven't been issued yet, that we wouldn't want to get tripped up if there was something in conflict there. So I think that's a good way to go.
So if I understand what was said correctly, and bear with me, but I just want to restate it because that's how I make sure I understand. What this is saying then is that we do have some latitude as long as we ensure that OLS attaches language asserting the primacy of the federal law. And as long as we do that, we have a certain amount of flexibility. Okay.
Right.
So now, with respect to I just want to go back because my understanding is the 1 to 3 months. If I choose 3 months, that means 3 months is not just for the application, but that has to be for the ongoing. So I can't pick 3 months here and use 1 month here, right? Or is that?
As I read ahead, I think actually what's proposed is that you have to meet if you will, the latitude that CMS gave, that we're choosing the 90 days before, if you haven't been eligible previously, and then once you are eligible, you have to show each month, and that would be allowable.
Okay. All right. So, Representative Markel, you had a question?
Yes, thank you for taking my question. Perhaps I missed this, but where does somebody who goes into business for themselves fall on this particular statute?
So it's neutral with respect to the way that you come into the program, but I think what you may be getting at when you talk about self-employed is that you would be, if you were a sole proprietor, as an example, that you would be providing evidence from your own records, if you will.
But that constitutes self-attestation, doesn't it?
I guess to the extent that there were, you could have some worries around that, but there should be, as I think as Representative Coppola was pointing out, there should be some bank records or something, or tax return or tax filing that could support that.
Okay. Question number 2, if I may, for a follow-up, sir? Thank you. What are we thinking about, and perhaps I missed this, what are we thinking about with somebody who may be involuntarily separated from their employer? And that might be an issue. And are we allowed to substitute or make congruent a community engagement program that maybe, in other words, can we hybridize this and say any combination of community engagement and or gainful employment, this kind of thing?
I think that's covered in the law if we
Yeah.
adopt the federal, and also I think looking ahead at number 9, that there's the latitude to have additional time to verify something, so that if you were sort of getting it together.
Okay. Thank you.
In the case of community engagement, how do you, because my wife has done a lot of volunteering and stuff like that. How do you do that?
There are different ways that it could be approached. For example, it could be that sort of the volunteer overseer would sign off on a timesheet of some kind, or that there would be some other logging in that could be provided. That is, I think, can be a challenge, but I think that it's potentially surmountable. may reduce the number of volunteer. You can't just sort of say you're doing it. You have to get some verification that you did.
No, I guess to Representative Markel's question, I mean, I think the distinction is between self-attestation and documentary evidence. So if there's documentary evidence, if I'm self-employed, I should have some documentary evidence of that. That could be incoming payments, could be, invoices to customers. I think invoices to customers would be an example of that. It just seems to me that there ought to be some documentary evidence which substantiates the claim, even if you're self-employed. Shall I move on to the next point then?
Yes, please.
Okay. So Roman numeral 3 says, Roman numeral 1 was definitions of applicable individual and work requirements. Roman numeral 2 we just discussed. Roman numeral 3 is no applicable individual shall remain enrolled in Medicaid in any month unless the individual has demonstrated compliance with the work requirements. So this is something you just alluded to.
I do think this one may be one where there may be federal rules around this, but I think as long as you have that clause, I think we'd be okay.
All right, so if there's no further discussion, then I'll move on to the next one, if that's okay, Mr. Chairman. Roman numeral 4, the Department of Health and Human Services shall verify an applicant's individual compliance with work requirements through wage reporting, enrollment in an education or training program, or volunteer service documentation. Verification shall occur on an ongoing basis at least quarterly between redetermination periods. Self-attestation shall not be accepted. And the only thing here I might suggest is that that this does specify wage reporting, enrollment in an education or training program or volunteer service documentation. We may want to make that more general, providing documentary evidence so that we can cover the self-employment scenario that was just described.
Yes. There are a lot of people who fit that self-employment. It's not the majority, but it's not it's not a small number. In terms of the verification shall occur on an ongoing basis, we're required to, so we would need to maintain coverage as you've got it here. You have to meet the requirement every single month. We have to do a eligibility re-verification twice under the federal law every 6 months. So a person who's coming on new to the program would have to do an eligibility before they get on, then every 6 months. This seems to add, is the verification, you're talking about eligibility, or you're talking about the work requirement itself? Because we're saying they have to meet it every single month. So that to me says we have to check every single month to see whether they're complying or not.
So good point. I think as I'm looking back at Roman numeral 3, I actually think this is simply saying they should be disenrolled if they are not demonstrating compliance with the work requirements for that month. Number 4 is saying that verification should happen at least quarterly. So I think I misspoke on number 3 when I was saying, yes, in every month you're doing that verification. What it's saying is, if there's a particular month where where you cannot verify that they've complied,
yep,
then they should not be enrolled in that month. And then there's a grace period further down, the 30-day grace period.
Because that's so there's a 30-day grace period. So, because my question would be, if someone is, let's say, things can be sketch. So I go and I'm unemployed, but I'm hustling right away, and I'm looking for employment, and I get it, you know, within, you know, 3 weeks, a month, or maybe 5 weeks, whatever. So there's that gap. What does that mean? How what would happen to that individual? So I'm working, I'm gainfully employed, I'm now unemployed, and I am aggressively looking for work. You know, I've registered with, you know, Employment Security, and I'm looking for work. 5 weeks later, it comes down, but I have this gap. So, but I'm verifying it quarterly. How do you see that scenario playing out?
That could cover a gap in coverage if they don't find another way to make up the hours that they were, so if they lost their job mid-month.
So they're looking for work. That's their employment right now. I'm looking for a job.
I'm trying to remember in the waiver that we had in the 18-19 period that there was a certain, for going to employment security and doing certain work, but I think that in this one, I'm kind of thinking that the federal regulations may trump what we have here in terms of what they see as the rights of that. I'm saying that, not having seen the rules because they haven't been published, but that they have a right to appeal a determination that we make, that's in the federal statute. But you know, just thinking someone who is just from a sequencing standpoint, I submit or don't submit any hours that I'm not meeting the requirement, so I lose coverage. But that coverage, is it retro or is it prospective? I think because if they have the month to submit the coverage and everybody's provided that service in good faith, you're talking about going forward, not the month that they were in. In other words, it'd be hard, I think, to administer it if you know, we don't know during the month that they haven't met the requirement. They have a certain number of days to make their reporting right to what they did. Then we have to check it to see that they're eligible, that they met the eligibility of doing either the community service or working. I just want to make sure that we're not going retro to it. I think that would be hard to do because we get the information whether they comply or not every day, but they have to have a certain time to report.
So the benefit loss, what you're saying is, would not apply in the past when they were unemployed. It would apply going forward.
That's a question I have in terms of the way it's written here, and I'm not sure what the
So-
intent is. Can we clarify that? I guess would be
If we were to set this aside for a second
yes.
and go back to the amending language we had last week
Yeah.
and the federal law, how does that situation play out? And you know, I know you haven't had time to really look at this. We're just looking at it quickly now, but how would that scenario play out with the existing federal law and the amended language we had 3 weeks ago?
I believe that the way the federal law would interpret it would be that if you didn't meet it in that month, then you would lose it the following month. You wouldn't lose it retrospectively.
And in the federal law and in the amendment we had 3 weeks ago, if somebody was unemployed for 5 weeks because, you know, no fault of their own, but things happen and they're pounding the pavement,
Right.
what happens to them in that scenario? Because now I've gone beyond the month. Okay, I've gone beyond the 30-day grace period. I'm now at whatever 37 days. So are they out and they have to show 3 months of full employment before they get back in? How does that? I'm just curious.
It could work as you just described. I think that's why I want to see what the federal regulation requires. But I do think that potentially that if the reason that they didn't continue to remain eligible just was because they were otherwise healthy, able-bodied, they right? That they lost their work, weren't able to make up the time during that month. They wouldn't make it for that month, so therefore they would be, not subject to, would not remain eligible. They would be able to regain eligibility by demonstrating, the 3 months.
Okay. Yes, Representative Kofal.
So I guess I'm hearing two issues. One is clarification on the timing of verification, non-compliance,
Right.
and loss of coverage and disenrollment. And I think it's a good point, and it's something I think clearly we need to be more specific about. So that's good feedback. I guess I want to just respond to the question or concern about somebody who's enrolled and then loses their job, that job search activities are themselves qualifying hours. There are a number of other things that constitute qualifying hours as well, including volunteer service, training, sort of training that would help you to get employment, and that you could engage in a combination of these activities if you wanted to ensure that you remain compliant with the work requirements. So I guess, that would be my response in saying that I don't think that that's an issue per se. It may be an education issue for those who are enrolled in the program, that it's important that you maintain these, full compliance with these requirements. These are all the things that could qualify for that. But if you lose your job, then, there are a good many other things, and it's 80 hours a month. It's not, it's you don't have to go spend your, full-time, make a full-time job out of volunteering at the local animal shelter. So
I appreciate that. I just want to kind of role play some of the scenarios in my mind so I understand, where, and with that scenario, if job hunting it's a qualifying activity, but if we take away self-attestation, how does that play out? Is that possible? I mean, are there mechanisms whereby somebody could show?
So I think that there probably are ways to get there, like working with employment security as an example. I do think there's also, I think there may be certain noticing requirements that are required of us as well in terms of when we can. I think if this is the way you'd like it, I guess it's just clarifying whether it's a retrospective loss of coverage or it's prospective. I think my suggestion, it really needs to be prospective, because the insurer's already provided the
Yep.
coverage and everything. But I think the clause that John suggested that will clarify it for us in terms of what we can and can't do there. I kind of see that as the safety valve language.
Yep.
Do you have a question?
Yes, I did. And thank you again for taking my question. Yeah, I'm looking at an assessment on this, and it does say from KFF that people who experience short-term hardships, this might be a hardship exemption, particularly if you're involuntarily separated due to no fault of your own. I'm also seeing here, it says that we could submit information to the secretary to allow for unemployment rate hardship exceptions. Is that something we'd be thinking of doing?
The unemployment provision, to my recollection and understanding, applies to a county, an MSA, or some federal designated area that you can exempt people in an area if the unemployment rate, I think, is over 10%.
Okay.
But on an individual case, no, if it wasn't in that area.
Okay.
And the OB3 had specific language in there about hardship, I believe, that said that CMS had no additional authority other than what was in statute.
Thank you.
Representative Kofod, are you ready to?
I am. Roman numeral 5, an applicable individual seeking an exemption from work requirements shall provide verifiable records for the exemptions sought. DHHS shall verify all exemptions and shall not accept self-attestation from individuals seeking exemptions. This is essentially just, we're saying no self-attestation for exemptions from the work requirement.
Here, the one thing I would lift up that's in the federal statute is if the state has access to records, they call ex parte determinations, meaning like, for example, if we know, they, for example, have a 8-year-old child enrolled in Medicaid, we know that information, they are exempt. We're not supposed to make them prove something that we already know. And so that if we had a source of information that we can access ourselves, that's already an established source. In other words, we don't have to create a new one, but that we're supposed to use ex parte, which basically just means based on information we know, to reduce the burden of compliance.
So it sounds like we would need to change this language from saying that the applicable individual shall provide the evidence to simply to expand that to say, or there shall be ex parte evidence of such exemption.
And I might put it in the ex parte first, and then the.
Okay.
Yep.
So may I proceed to the next
Yes,
item then?
please.
Roman numeral 6, DHHS shall not seek or implement any additional optional exemptions under 42 USC, et cetera, or any other program waivers without obtaining express approval of the Executive Council. This one I know is, I guess this one is just one where I feel like there ought to be some, I'll say, voice of the people in sort of determining what additional exemptions or waivers we're applying. I think that having the legislature take on that function is cumbersome and could potentially take a very long time. So I had proposed that the Executive Council might be the proper body to do that. It's certainly not the only body that could do that. There are others that could serve that function. So can you comment on that?
I think this is probably one where I'm not sure I'm qualified on sort of what the constitutional roles are in there as to whether this would be considered something that's not within their purview. So I think that would need some research, Representative.
Agreed, that probably is a legal question.
Representative Woods?
Yes, just a general question. This says, shall not seek or implement additional exemptions. What about if we wanted to remove an exemption?
That would not be included under this.
Okay, this is only for additional.
Correct. It's essentially a one-way safety valve.
Okay.
Yes.
Okay, just to clarify.
All right, ready to go?
Okay. Next up is Roman numeral 7. DHHS shall not accept exemption designations, approvals, or determinations by a managed care organization. My understanding, this is one that I sort of have. I'm questioning whether it's needed because I think that we're already. I mean, federal law is a little bit broader or a little bit less specific. It says by a managed care organization that has a financial interest in. So I think it's close. I put it in here anyway, but it's one that I'm maybe more likely to strike from this draft. So I'll let you comment on that one.
I think you could strike that one because decisions on eligibility have to be made by the state, and there's explicit in OB3 that they can't make decisions. They can assist someone in, like, for example, they could, if someone needed to prove that they were hospitalized and they could maybe provide them with documentation. I don't think that's what you're trying to say it's really that they can't make a determination that they've met it. They could just provide records.
Mhm.
I think that one's covered pretty well in the statute.
That was, I suspected that that was the case. I put it in here anyway, but I think that's one that could be stricken from the proposed language easily. Shall I continue then? Okay, Roman numeral 8 is a bit longer. The department shall only approve an exemption for an individual based on the status of medically frail or otherwise an individual with special needs if the individual has been medically certified per statement from a physician, physician assistant, nurse, nurse practitioner, designated representative of the physician's office, licensed or certified psychologist or social worker as having disabling mental disorders, having a physical, intellectual, or developmental disability that significantly impairs their ability to perform activities of daily living, including eating, dressing, bathing, grooming, getting in and out of bed or chairs, walking, going outdoors, using the toilet, or in treatment for a chronic substance use disorder. In no case shall the department expand the definition of medically frail or otherwise an individual with special needs beyond the scope of the definition established under 42 CFR 44315. So I think this is just, the intention here is to just kind of draw a line and say we don't want to go beyond the existing definitions under OB3 of what constitutes an exemption. So is that, I mean, it's maybe a little bit duplicative of Roman numeral 6.
And this is, if just a question here, this whole paragraph relates to the determination of medical frailty only, correct?
Yes.
And I guess I would, in terms of the CFR citation, I don't know that off the top of my head, but would want to just verify that.
So in this case, this is kind of dovetailing in with the federal language, but if the federal language changes, does the proviso that we talked about earlier allow us, we're covered? Cause I mean, right now this is reasonable. It dovetails, like I said, but if it changes for any reason, I don't want to have a whole bunch of people drop. So we're covered, is your belief.
I think with that language that John talked about earlier, I think at the end of the day, I think we understand that the legislature wants a work requirement implemented. You wouldn't want us to be delayed by trying to challenge federal law, right?
So I agree that that is an important provision, and it should apply to all, everything here. So Roman numeral 9, I think, requires further clarification per your comments earlier, Director Lippman. Just for the benefits of those who may be watching the streaming, any applicable individual who fails to comply with the work requirements shall be provided notice and an additional 30 days to supply verification of compliance or exemption. After the 30-day notice period, the department shall disenroll any applicable individual who does not demonstrate compliance with the work requirements or qualify for an exemption. So I think the main thing here is probably that we need to clarify that sort of retroactive versus prospective timeline. But otherwise, do you see any issues or concerns with this language?
I need to take one more look at it, sorry. I think with the proviso and that it apply prospectively, I think we're probably okay.
Okay. I also want to apologize. I know you got this, everybody here got this last minute. That's my fault. And so I would invite you to take some more time to digest it and, share with the committee your, any issues or concerns that arise as you've had a chance to look at it in more detail.
There was one thing that you mentioned about this being what we if federal law went away, we would then be subject to have to applying for 1115 waiver. The 1115 waiver, we could have this this is what the legislature passed, but as happened previously, we had language that the same kind of language with John with respect to the waiver, that you wouldn't want us to take a position to not get a waiver if it was like issues that CMS wouldn't approve. Like there were some things in our law that we had to, that if you go and look at the actual waiver that was issued, that vary from the law, and there was a requirement that's in our current statute that described what the process was informing where they didn't agree with us and what we tried to do to make it work.
Cool, Paul.
Would it then perhaps make sense that we put another umbrella statement on all of this saying that if we, if this is repealed at the federal level and we're back into a waiver, then everything we're talking about here is suspended, pending, or is suspended, period.
Suspended
or
until we
repealed.
get another
Or-
waiver to, and what
Okay.
those terms and conditions are.
Okay, yeah, so let me think about what that might look like. I think, I understand where you're going with it, it makes sense.
Yes, Representative Woods.
Thank you. Just, is there any necessity, trying to avoid being too nitpicky, it says to provide notice, it doesn't say how. It gets into the issue of sometimes, if it's close, if you send it by snail mail and the person doesn't pick up the mail, it may go 2 weeks before they even know it, and then, et cetera, et cetera, et cetera. Or if you notify by email, well, we sent a notice out, well, I don't have email. Is there any necessity, especially in this particular group, of having some other clarification or specific identification that notification has in fact been promulgated and perhaps even received?
I suspect that the federal regulations implement this will provide specific noticing requirements. Usually on eligibility, there are concrete requirements we have to comply with and be able to document.
Okay. Representative Cope. Oh, Representative Markello, do you have a question?
Oh, well, no, I was just thinking with regard to Representative Woods' remark on notice. It's been my experience that notice is basically going to be whatever is required under the circumstances to put the receiving party, provide the necessary information. So that could be email, it could be fax, it could be snail mail, anything that basically provides them with notice. And, when you drop a letter in the mail, the presumption is it's going to get there. Or in the extreme case, you could just put a newspaper publication, but I don't think you need to do that. I don't think you have to go that far. It's just what should be reasonably construed to provide them with the information.
Not trying to be, it could also be, just like if you go to the bank, how do you want to be notified? And you can identify, well,
Sure.
by this cell phone number, this email,
Sure.
and you identify how you want to be notified.
Sure. So in other words, somebody says they didn't get notice. Well, we mailed the thing out on this and date, and it didn't come back to us. Remarked as undeliverable or something like that. So the presumption is you got it.
And I'm pretty confident from experience on noticing that they'll be very concrete with what we have to do to satisfy that.
Representative Cope, do you want to?
Okay, I think the last two are already included in the draft language that we saw at our last meeting. One is a quarterly report to the Senate President, the Speaker, Governor, and others. And the last one is work requirements shall be implemented no later than December 31st, 2026, or earlier if permitted by federal law and approved by CMS. And I think both of those provisions, slightly different language perhaps, but I think both of those provisions are already included in the draft language that we reviewed at our last meeting.
we were just talking between ourselves about 11, Roman 11, in terms of we could get approval, but we also have to perfect that the technology, that the systems will work. So I think the December 31st date is fine. I think in terms of doing it earlier is going to be tied to that we can actually all programmed and worked, and that we're able to do all the things that you said above there, like being able to intake the information and to process it properly.
So you would keep the original December 1st date.
31st.
December 31st. Yeah.
Yep. And so I do think it is probably redundant to say no later than
No,
December 31st
December.
or earlier, if possible. No later than kind of covers it. Is that
Right, no later than December 31st is
Okay.
the federal requirement. The December 31st date is going to be, we know that from the legislature, from the governor's office, and from CMS, that to be able to get a extension to that date is going to be a difficult thing to achieve. And we're working, assuming that we have to meet that December 31st deadline. So that's what I'd like to have remain there.
But
Okay.
The,
So
the original amendment said December 1st,
I
not
think this-
December 31st,
yeah.
but December 1st.
Oh, it
and
does,
was that to
actually.
give you
You're right.
buffer room, or what was?
That's fine.
so I'm going to suggest then the language I have here I will strike out of my things to change or things to add. And the previous one, I'll review it again, but I think you've pretty much already included that, or the Senate pretty much already included that. So I think that probably can be stricken as well. So I guess it just, if I may review, it seems to me that the changes I've noted is for Roman numeral 4, changing wage reporting enrollment, as the various kinds of documentation to simply saying documentary evidence, so that we have a broader definition there. Under Roman numeral 5, to specify that ex parte evidence records is allowable under certain circumstances. It is allowable. Period. Roman numeral 6, reviewing sort of the constitutionality of, is it the executive council or is it potentially some other group that represents elected officials that would be part of that review process, and then clarifying retroactive versus prospective, and sort of what would the timeline look like for somebody who is out of compliance, and then striking Roman numerals 7, 10, and 11.
So we understand. So what you're saying is you're going to beef up 4, 5, and 6. 1 is just definitions, which is fine. But 2 and 3, you're keeping those as well, right? But you're saying that language is we keep that kind of as is. Is that what you're saying?
Yes.
So okay.
Yes. And again, I would invite the department to, when you've had a chance to more fully digest this, to provide input as to what that should look like.
I think I heard you though say earlier that the safety belt.
Oh, I'm sorry.
Yeah.
Good, very, very good catch. Yes, that would be the other thing at the top of the page. Exceptions, exclusions as stipulated by federal law. So, so that we have a kind of a safety valve in in that event.
It'd be by law or by federal authority. In other words, CMS.
Yeah. So federal law, yeah, I'm including both statute and rule.
Yeah.
So yes, and so OLS will have that language, and we'll have them
Yep.
incorporate it.
So okay. So are you good then?
Yes.
Representative Markel, you have a question?
No, I'm just listening, thank you.
Okay, so does anybody else in the committee have any, thoughts or comments, having kind of gone through, the 11 points, before I kind of dig in a little bit? Any other thoughts? Okay, so to kind of summarize, it sounds, Representative Colfault, like what you're asking to do is you're going to take this, you're going to clarify some of the language, retroactive versus prospective, bring in some of that umbrella language that, makes it clear that we have the supremacy of the federal law, and we're going to cede to that if there's any changes or any difference. So that's something you would be looking to do.
Yes, so what I would propose is that I work on making those changes, sharing the language that comes out of that with the department and with the subcommittee. I would ask that any comments from subcommittee members not be copied to all, so that we can avoid having an illegal meeting, but that there just be a sort of feedback on if there are issues or concerns, and that we may want to, I don't know if you would want to schedule another subcommittee meeting, or schedule a subcommittee meeting shortly an hour before or half an hour before the full committee meets, just to save people some travel time.
Let me just, part of me, if these changes are substantive and we get additional feedback, I think I'd want to get kind of everybody together so that everybody has had a chance to look at that final language rather than just an hour before the committee meeting. Because I think, what I would like to do is at least have everybody on this committee confident and have the time to review that language another hour. So I'm okay if everybody else is okay with, coming back for another meeting just to make sure, because this is going to impact a lot of people, just to make sure that this language is very tight, and to kind of read your feedback as well. So, how long do you think it would take to do what you're looking to do? Representative McDonald, who's the chair of the full committee, was looking to go and get us all together either on the 5th or the 12th. I mean, it's going to take a little time. I could push him out to the 12th. I don't think he's going to want to go beyond that. So what are your thoughts with respect to that?
So I want to be sensitive to the fact that OLS is
Right.
working around the clock right now.
Yeah.
And we've given them quite a few bills to draft. So I think it probably depends most on OLS. I'd also think we are not necessarily giving them simple changes on a simple topic. We're giving them relatively medium to complex changes on a very complex topic.
I would agree.
So I'm going to say I think I could get something to OLS by Friday of this week. The question really is, how long will they need to be working on it in order to come up with good tight language? And then I think if we all have at least a day to look at that before the next meeting, that would also be helpful.
So, I mean, do you think it's reasonable that we get together in 2 weeks? And that gets us, I think that's the 5th, right? Is 2 weeks? I don't have a smartphone, so I guess I don't have the built-in calendar. 2 weeks is the 5th.
So I'm gonna be out of town
Okay,
on the 5th. So the 3rd is available for me, and
Which is
I'm
the
wondering
Monday?
if that would work for others on the subcommittee.
okay, so November the 3rd, that's a Monday,
Mhm.
correct?
Yes.
Representative Whitaker, here's my calendar. So does that work for everybody else?
Not for me. I should be on my way to Southeast Asia on that day.
Oh, so the 5th probably wouldn't work for you either then?
No.
Okay, so are you,
I'm out until my return flight from Hanoi is, November 23rd.
Okay, so you're not even gonna be back for the meeting of the whole committee then?
I'm gonna have to get a substitute, I would think.
Okay, so would it be okay then, under that circumstance where you wanted me back for and it's just gonna be a sub, would it be okay if we proceeded without you? Are you comfortable
Yes,
with that?
I'm comfortable with
Okay.
that.
So with that being said, then, I'm okay for the third. Representative Wood's okay for the third. And if for some reason you get into OLS and they say this is a real tiger, I mean, we can always, postpone or change it. But for now, I would like to get it kind of down. And I'll talk to Representative McDonald to maybe bring in the full committee for November 12th, if that works. I mean, or do you want to maybe try for the 5th? If we come in on the 3rd and it looks tight, do you want me to go to Representative McDonald and say, hey, let's try for the 5th? Well, you're up, you said, so
I
that's
will
not
be
gonna
out of
work.
town.
So we'll have to go for the 12th anyway, because I'll want you to be talking to it maybe at some points rather than me. So if that works for everybody, that being said, is it worth it in parallel to submit the language that we had 3 weeks ago from Senator Pearl, or are we confident enough that we think we can have something on the 3rd?
I think it would be a good idea for us to submit both.
Okay.
Because there may be some, when we meet as a full committee, there may be some who would lean towards a sort of a less restrictive approach. And, although I am in favor of a more restrictive approach, I want to respect the fact that we have timelines.
Yes.
And that we need to, and this is not this is not something we could just kick the can down the road. We've got to pass this, because if we leave existing statute in place for too long, we go to the end of the line, and that costs the state money, and we don't want to do that.
Right, and I appreciate that, because that's very much on my mind. So I would like to, I'm hoping that we're going to come in on the 3rd, and given some of the language that recognizes, the federal supremacy, we're going to be able to have something good. But I would like to have something in my hip pocket just in case. So I will go to OLS, and I will get this language that we had 3 weeks ago as a formal amendment. You'll work on what you're going to work on, Representative Kofalt. We'll get together on the 3rd. I'll get with the folks to schedule that, and I'll let Chairman McDonald know that we're going to get together as a whole, as long as he goes along with that, for the 12th. That was the other date he proposed, so I'll see if that works for him. Yes.
So just a point of clarification, what I'm going to be bringing to OLS will piggyback on the language that was already provided, that we reviewed last time.
Yes.
So with one change, which I mentioned, which is there's a section in there that suspends anything in anything in the existing statute that pertains to work requirements is suspended unless or until the federal government repeals a work requirement.
Okay,
So
you're
that
asking,
would need to change slightly in mine to say, yes, it's all suspended except these new things that we're putting in. So I guess what I'm saying is mine's gonna be that mine's gonna be the same as what you're bringing, plus some additional provisions. It might be more efficient if I just go to them and say, here's the original language, and if you want to have your name on that one, that's fine. But I am going to say you already have this language, and we're probably talking to the same drafting attorney anyway.
so just to be clear then, so what you're saying is you're going to actually submit both amendments.
I'm suggesting that it might be more efficient if we
Okay.
do it that way.
So you'll submit both amendments, and you can either put me down on the first amendment, or as a co-sponsor, whatever. So
Okay.
I'm fine either way. If you want to have co-pilot amendment number 1, co-pilot amendment number 2, and so whatever you decide. I just want to be clear that you're, so that we don't show up and I haven't done my job and I don't have the amendment, because you're going to look
Yeah.
after both.
I will take care of both. Yes.
Okay, so with that being said, then, we'll get together on the 3rd. I'll get that scheduled, and then hopefully Chair McDonald will start the final thing. And Director Lippman, you have a question?
Do you have a time on the third, just, the reason I'm asking is that I know the third may be a very busy day for us, because that's the day we have to submit the rural health transition program grant, so I just wanna,
I can accommodate you. I don't know about Representative Kofalt and Representative Woods, but
if you met the same time as today, that would be, at least I would have the morning to,
I'm actually wide open that day.
okay. So then we'll go for the 3rd at 1 o'clock. Are you okay for that, Representative Woods?
could make a change.
Okay, all right. So we'll do that. We'll get together on the 3rd and we'll talk to the chair of the committee. And does anybody else have any other business or any other comments? Okay, that being said, this meeting is adjourned and thank you very much.
thank you.